Fallon, good afternoon, sir. If you'll raise your right hand and sworn, please do solemnly swear affirm that I will support you and nothing but the truth. Thank you. All right, Mr. McDonald, please, in terms of the negotiated resolution.
Good afternoon, Judge. I'll go through one case, one count at a time. I already made it for the runner out. 23-1103, we read the resolution. The terms are as follows. You plead no contest, count 2, possession of controlled substance, adjudication of guilt, cost of court $415, cost of prosecution $100, cost of defense be a $50 application fee, and $100 for time. 36, that's 36 months in Florida Department of Corrections who will receive credit for any time served. There would be $100 to the state and local drug court funds respectively, 6 months driver's license suspension. We would ask the court has an objection to obtaining a hardship license if otherwise qualified. We would submit a DNA sample to the FDLE DNA database. The outstanding monies would go to a court's payment plan. Counts 1 and 3 would be no process exchange for that plea. This will run currently all cases, all counts, which we will go on to. In case 23-1114, the terms are as follows. Count 1, sale of controlled substance. You plead no contest. Adjudication of guilt. Cost of court $415. Cost of prosecution $100. Cost of defense would be a $50 application fee, $100 for attorney's time. 36 months in the Florida Department of Corrections. Credit for any time served. That will bring the current case to the case we just announced.
If we could have anybody who speaks step outside, please. Thank you.
And I can speak up if need be too.
I don't see much to speak over.
I think I got that. How am I just finished?
No, you did not. You only announced the president.
Okay. And we'll be credit for any time served on count 1.
And you also announced all.
And that will be followed by
There you go.
36 months drug offender probation, 10 p.m. to 6 a.m. curfew, and be adjusted for work purposes. There would be $100 to the state and local drug trust funds respectively. You would undergo a substance abuse evaluation and follow any recommended follow-up treatment. You would undergo random drug testing and searches. Perform 50, that's 50 hours of community service. We would ask for the option 5 an hour, rate of $10 per hour. There would be a 6-month driver's license suspension per statute. Again, we would ask if the court has an objection to obtaining a hardship license, if otherwise qualified. There would be no contact with Andrew Vega. That actually applies to a victim case.
is punishable by a maximum of 15 years in state prison. To that charge, 5 years to plead. To the charge of count 2, transportation of paraphernalia, for the felony, punishable by a maximum of 5 years in state prison. To that charge, 5 years to plead. And to the charge of count 3, possession of controlled substance, a third-degree felony, punishable by a maximum of 5 years in state prison. To that charge, 5 years to plead. You're also before the court sorting case 23-1104 after the charge of compliance, salary delivery of controlled substance. Again, a second-degree felony, punishable by a maximum of 15 years in the Department of Corrections. To that charge, 5 years to plead. To the charge in count 2, possession of a controlled substance, and the charge in count 3, transportation of paraphernalia, both charged as felonies, both punishable by a maximum of 5 years in state prison each. To those charges, 5 years to plead. And finally, in case 23-1081 after the charge in count 2, battery that is a first-degree misdemeanor, which is punishable by a maximum of 1 year in the county jail. To that charge, 5 years to plead. Do you understand, sir, that by entering your no contest plea agreement, you're giving up your right to agree filings in all 4 cases? You're giving up your right to see state witnesses, have your attorney cross-examine those witnesses, your right to call witnesses on your behalf, your right to either testify on your behalf or to remain silent, your right to present any defenses you may have, and right as a state for these charges beyond a reasonable doubt to the jury. Do you understand all of that? You also understand, sir, that you're giving up the right to appeal all matters except this court and impose this sentence. Other than what was announced, does anyone threaten you or promise anything different to get you to plead? Are you entering the plea of your own free will? Do you believe this plea is in your best interest? And did you sign all 4 plea forms? Do you have any questions? Are you satisfied with the advice and counsel of your attorney, Mr. McDonald? Has he done everything you've asked him to do? And has he been able to answer all of your questions? Do you understand, sir, that if you are not a U.S. citizen, any of your plea may subject you to deportation? You also understand that battery is an cancelable offense. What that means is, should you be arrested for a battery in the future, this conviction today can be used for penalties, your charges, or for more severe, because you can delegate what would normally be a misdemeanor to a felony conviction of offense. Counsel, do you stipulate the factual basis standing in the score sheet?
Yes.
At this time, the state would announce no process counts 1 and 3 in case 23-1103F, and announce no process count 1 in case 23-1081F, subject to the court's acceptance of the plea. State would ask the court to take judicial notice of the court files with the release.
Thank you. I would accept your plea. I'll find that you knowingly, voluntarily, and intelligently made. But you understand what you're doing here today. There is a factual basis for each of the charges for which you've been plead in these multiple cases, and you've been represented by good and competent counsel to negotiate a very favorable outcome for you based upon the facts of the case and your prior record. In fact, you negotiated 36 months state prison on all of these cases in your prior history. Had you gone to trial, it's likely that you would have been facing a substantial amount more than this. I'm not privy to the discovery, so I don't know how good or bad each case was, but I'll say that based upon the numbers and based upon the priors, this is a very good resolution. In case number 23-1081F, to the offense of misdemeanor battery, the court will adjudicate you guilty of that offense, sentence you to time served, court costs in the amount of $220, $50 cost of prosecution, $50 public defender application fee, $50 fee for services of the public defender. There would be $151 payable to the Rape Crisis Trust Fund and $201 payable to the Domestic Violence Trust Fund. You would have 10 days from your release from incarceration to get with the clerk's office to work out a payment plan for the outstanding obligations. Should you fail to do so, that will be converted into a civil judgment against you. In case number 23-1103F, as to count 2, possession of a controlled substance, you will be adjudicated guilty of that offense, sentenced to 36 months in the Department of Corrections, that you will be given credit for all times of service, and that will run concurrent with all cases, all counts, in particular, concurrently with case number 23-1081F, 23-1104F, 23-1114F, services of the public defender. Additionally, you would have $100 payable to both the state and the local drug trust funds. Again, you would have 10 days from your release from incarceration to get the clerk's office to work out a payment plan for those outstanding obligations. Now, the state in this case, I believe, has given all cross counts 1 and count 3, and in the past, in the previous case 23-1081F, the state is announced to nullify count 1. In case number 23-1104F, having accepted your pleas to counts 1, 2, and 3 in this case, the court will, it's to count 1, you'll be adjudicated guilty, sentenced to 36 months in the Department of Corrections, with credit for all the time that you have served. That will run concurrently with case numbers 23-1081F, 23-1103F, and 23-1114F. Following your incarceration, you will be placed on 36 months of drug offender probation. That will be, you will have a 10 p.m. to 6 a.m. curfew as part of that drug offender probation. Within 30 days of your release from incarceration, you will sign up for a substance abuse evaluation, show proof of that to probation, and then follow all the recommendations from that. Be subject to random testing and random searches upon request. You would have 50 hours of community service. You may pay that off at the statutory rate of $10 per hour should you choose. There would be a 6-month suspension of your driving privilege. The court has no objection to obtaining a hardship license should you otherwise qualify. That's likely going to begin when you get released from incarceration, or I should say not sooner than that. You'll be subject to DNA testing for placement in the FDLE database. Pay court costs in the amount of $415, cost of prosecution in the amount of $100, $50 public defender application fee, and a $100 fee for services of the public defender. There will be $100 payable to both the state and the local drug trust funds. Any question that needs to be addressed?
How long does he have to sign up for the substance abuse evaluation?
30 days. 30 days from when he gets out of jail, out of prison.
Line up your job during that time.
You have to sign up for it. You don't have to start it, but you have to sign up for it so we know you're getting going.
All right. Yeah, you can get
Okay.
an appointment
It's a
time.
condition of your probation. Count 2, possession of controlled substance and adjudication of guilt. 36 months Department of Corrections to run concurrently with count 1 and 3 and all other counts as announced today. There would also be the 6-month driver's license suspension with no objection to a hardship with respect to that count. Possession of narcotic paraphernalia, count 3, adjudication of guilt, 36 months Department of Corrections to run concurrently with counts 1 and 2 and all other counts as announced today as well. In case number 23-1114F, count 1, sale of methamphetamine, you'll be adjudicated guilty of that offense, 36 months Department of Corrections with credit for time served to run concurrently with all counts and cases as announced today. That would be followed by 36 months of drug offender probation with a 10 p.m. to 6 a.m. curfew. The substance abuse evaluation is sign up for that within 30 days of your release from incarceration. Follow all recommendations. Be subject to random testing, random searches. 50 hours of community service payable at the statutory rate of $10 per hour. 6-month driver's license suspension. No objection to a hardship license. DNA sample to be provided to the FDLE database. $415 in court costs, $100 cost of prosecution, $50 public defender application fee, and $100 fee for service of the public defender. Additionally, there would be $100 payable to the state and the local drug trust funds. Additionally, there would be, as a condition of your probation, and there would be no contact with Andrew Vega as negotiated in this global resolution. As to counts 2 and counts 3, you would be adjudicated guilty. There would be 36 months concurrent probation, all counts, all cases. As to count 3, you would have a 6-month driver's license suspension with respect to that case. No objection to a hardship license. To reiterate, all counts, all cases run concurrently as it relates to everything but the community service hours. You have to do 50 per case that was set forth there, so 100 total. Anything further, Ms. Detzel? Mr. McDonald?
No, Your Honor, that's everything.
All right, Mr. McDonald, good luck to you. Please step to your left to be fingerprinted. You have 30 days to appeal.
Thank you, Your Honor.
You can go, Judge. I was just indicating you can wait if you want to do that.
That's all right. We'll go ahead and take your matters.
Yes, sir.
You have Centavius, right?
Yes, sir.
Case numbers 22-1974F and 22-1975F.
Your Honor, should we need another copy of the score sheet? It was provided on Monday.
I don't think so. Let me double check. Is the state objecting to the request for designation of youthful offender? Okay. You know what, I will need another score sheet though. Yes, please. Thank you. Table. Good afternoon, Mr. Wright.
Good afternoon, Your Honor.
All right, Mr. Wright, if you'll raise your right hand and be sworn, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. I believe we accepted the plea previously on this, and this was set for sentencing today.
Yes, sir, that's correct, Judge. Rob Denny on behalf of Mr. Santavius Wright. Mr. Wright's obviously in the courtroom podium. Judge, to kind of expedite things and keep things streamlined, I'm going to make some representations and proffers and validate or otherwise verify with Mr. Wright that what I'm representing to you is accurate. Mr. Wright was born on February 27th of 2003. The date of the crimes in the two cases before you, Judge, was December 21st of 2022. That puts him 19 years old. He's about 2 months shy of his 20th birthday. Mr. Wright was raised by his mother and his maternal grandmother. His maternal grandmother passed away when he was 12 years old. His mother passed away when he was 14 years old. And he was thereafter raised by his maternal great-grandmother. Mr. Wright has a 9th grade education. I want to point out to you, despite what you read in the probable cause affidavits, and I know Ms. Detzel will do her job and present her side of the case, Mr. Wright has not been arrested or picked up on any new charges while our cases were pending. I know you're going to consider the score sheet and look at his history, and I know while I was going to give you a moment of concern, I do think it's appropriate for you to consider that while he has been dealing with this, it appears as though he is heading down a different road, a better road in his life.
How long has he been out? And I know I remanded him the other day, but how long has he been out?
My recollection is he got out in June, so he's been out about 7 months. Is that about right, Mr. Wright?
Yes, Your Honor.
So I pointed it out to you last time. I will repeat it again. I think it's worth repeating, and I think it's worth you seriously considering. Despite being late for court on some or many occasions, depending upon the subjective review of that, the man lives in Tampa, and he was able to make it here every single time. He didn't throw up his hands and give up. He didn't say, you know what, I'm going to be 2 hours late. Let's go ahead and let him arrest me on a warrant, or I'll turn myself in later. I can represent to you that he was absolutely steadfast in calling our office, keeping our secretary updated, and either passing the information to me or one of my colleagues to pass to me. What are his opportunities if you're willing to let him out? He has a residence with his girlfriend and his girlfriend's mother. He has been employed in the past. He worked his most long-term opportunity, or his most long-term success at employment was through a temp agency. It was through Randstad, a company in the Tampa area. Now, as a temp agency, they placed him at different jobs, so he wasn't at one particular location for a year, but he was at least with that agency continuously for a year. He has had other jobs of shorter periods of time, but I think as a now 20-year-old approaching 21 years with what I've already told you about his background, I think that is something substantial. I received 2 messages today from a Mr. Martinez advising or leaving messages that he does have employment for Mr. Wright. Apparently Mr. Wright has worked with him in the past in some sort of auto shop type job. I'm not entirely clear of that, but that is what was left on my message machine. You'll see his prior record. You'll see he has a juvenile record. And speaking with Mr. Wright, Mr. Wright's advised that he's never been sentenced to a DJJ program. He has had juvenile program. He has had juvenile probation previously. And the only one point I do want to point out about one of the facts, or about one of the charges on his case is a grand theft auto. It's my understanding. I'm not trying to minimize it, but I am trying to place it in its appropriate context. It's for the theft of a golf cart when he was 17 or 18 years old, somewhere in that range. The score sheet seems to reflect that it was not as a juvenile offense. I did speak to Ms. Detzel, and we have verified that grand theft auto was a juvenile offense. Now, Mr. Wright does have other offenses that he picked up as an adult that preceded the arrest in this case. I'm sure Ms. Detzel will go into that. When you consider what to do with him, Judge, I am asking that you consider his age. I'm asking that you consider his family factors. I'm asking that you understand his education and lack thereof to respect the purpose of a youthful offender designation. That is for a relatively young man with I don't want to say undeveloped in an offensive way, but undeveloped in the educational, social, and social responsibility way. I think that's exactly what you have standing in front of him. I think he is headed down a much different path than what he has gone down before. You have, like you suggested when you took his plea, you have a substantial amount of time to work with and how you want to fashion what is appropriate to punish him for what he did and keep the court's hands on him to make sure that he follows through with a better path of life, or if not, address it in the future as you see fit. Specifically, I'm asking that you give him 10 years of probation. That's what I'm asking for. You're able to do that with the youthful offender designation. Mr. Wright, everything that I have represented to the judge factually...
Youthful offender, I can only do 6.
I'm sorry. That is correct. I'm sorry, Judge. You are correct.
Your Honor, my understanding is because if you apply the WIO designation, it would apply to each case separately, and there are 2 separate cases. Each case would have been capped at 6 for the statutory max. So you have good 233 felony. I think it's again not one consecutive for purposes of conviction.
Maybe I can. Okay. All right, State, what are you asking for?
Well, just very quickly, Judge. Mr. Wright, let's just get it on the record. Everything that I have represented to the judge, if I told the truth,
Yes, sir.
everything is factually accurate based on our conversations and what you know to be the truth.
Yes, sir.
All right.
All right, thank you. State?
Yes, Your Honor, if I may, I'd like to give a little bit of detail about Mr. Wright's criminal history and a little bit of actual background about the cases that Your Honor may not be privy to in the probable cause application. As Mr. Wright stands before you, Your Honor, he is 20 years old and he will be 21 later this month. For someone that is 20 years old, Mr. Wright scores mandatory prison on his score sheet. For a gentleman who is just 20 years old, he has 8 felony convictions as a juvenile, 8 felony priors, 14 misdemeanor priors as a juvenile. At 20 years old, he has 4 felony convictions as an adult and 1 misdemeanor conviction as an adult. Mr. Wright was first arrested in 2015. He has a case from 2016, 4 cases from 2018. And these are only ones that resulted in conviction, Your Honor. 1 case from 2019, 8 cases in 2020, and he was out on bond in 2 separate felony cases as an adult in Hillsborough County at the time he committed these offenses for which he's before the court. He has since pled to those offenses. So what is not on his score sheet, Your Honor, is that in Hillsborough County in 2022 cases, he was also convicted of burglary of a dwelling, grand theft from a dwelling, possession of cocaine, possession of a controlled substance, and possession of paraphernalia in Hillsborough County. This is a young man who, while extremely young, has done nothing but chance after chance after chance, break after break after break. Never went to a program as a juvenile, despite having, as a juvenile, burglary of a dwelling, grand theft of a firearm, multiple burglary of conveyances, dealing in stolen property, grand theft auto, improper exhibition of a dangerous weapon. This is someone who, despite scoring mandatory prison on a burglary of a dwelling, grand theft of a dwelling, and multiple counts of possession out of Hillsborough County, got a credit time served downward departure offer.
But is it really fair to say that that's... look, the offenses are him, but didn't state attorney's offices throughout the state have an opportunity to send him to a program, to send him to prison, to do the things that you're suggesting they didn't? And I know it would be different in Charlotte County, but in Hillsborough, it was what it was. So I think...
And some of these are post-adjudicatory hearings. Some of these were the court, not the state. So I just want to point that out. So the court up in Hillsborough did have those opportunities. But I'm simply pointing out the continued, what the state perceives as rights. So in the incident cases, Your Honor, the incident cases are Mr. Wright and two other of his friends stole a vehicle in Hillsborough County. They proceeded to come southbound on I-75. Hillsborough County was not able to get to the interstate in time. They radioed to Sarasota. Sarasota put their aviation unit up. Aviation was able to find the vehicle in Sarasota County. However, before Sarasota unit could make it to the interstate, the vehicle crossed into our county. We pick up the vehicle going southbound on I-75 just before the Jones Loop exit. Law enforcement gets behind the vehicle and initiates lights and sirens, and let me be very clear, the defendant is the driver. The defendant immediately accelerates, cuts across 3 lanes of traffic from the left to the rightmost lane, passing multiple cars, then cuts back across all 3 lanes of traffic, cutting off the truck in the left lane, continuing to accelerate. Law enforcement immediately cuts off pursuit due to the dangerous actions of the defendant. At one point, the defendant cuts into the breakdown lane or the shoulder at I-75, passing 3 full lanes of traffic at just shy of 90 miles per hour. He continues down I-75, moving across and back all lanes of traffic, passing traffic, climbing to speeds in excess of over 100 miles an hour. At one point, it climbs to speeds in excess of 120 miles an hour. The vehicle exits at a high rate of speed onto the Tucker grade exit, almost losing control of the exit ramp after taking a curved turn at a high rate of speed. It continues down Tucker's grade, turning down a side residential street, cutting around traffic and exceeding speeds of 70 miles an hour on the 2-lane residential road. The vehicle eventually comes back to US 41, where it continues northbound, quickly accelerating again and weaving in and out of traffic. As the defendant comes to the intersection of Tucker's grade and 41, he goes into the far right breakdown lane, passing stopped traffic at the red light, going into the intersection at just shy of 70 miles an hour. And when other law enforcement vehicles appear to be turning from Tucker's grade with lights, he cuts across the intersection to the left, now traveling on the wrong side of the road in the southbound lanes, traveling north still on US 41. Law enforcement again immediately disengages due to the reckless actions of the defendant. The defendant eventually cuts back across 41, now back into the northbound lane, continuing at a high rate of speed, again in excess of 100 miles an hour. As the defendant passes Taylor Road, there is a car in the left lane, a school bus in the right lane traveling next to one another. The defendant cuts between the car and the bus in the middle of 2 lanes, cutting off the school bus to continue to flee at excessive speed. As the defendant approaches the intersection of Jones Loop and 41, he again starts to weave in and out of traffic and cuts around traffic stopped at the red light, going into the rightmost turn lane, but then cutting straight across the intersection, barely missing colliding with a vehicle turning onto Jones Loop. He continues north on 41, again exceeds excess of 70 miles an hour, going up to over 90 miles an hour. He turns onto Cooper Street, still traveling at a higher speed, blowing through the stop sign at Cooper Airport before finally turning into the apartment complex and ditching the vehicle. At no point, Your Honor, except as previously mentioned, did law enforcement chase or follow the vehicle, and yet he continued to act in an extremely reckless manner. When the defendant exits the driver's seat, he's wearing gloves, he's carrying a backpack that he later ditches, as he and the 2 others walk around the back of the apartment complex, where they are ultimately apprehended by the Pensacola Police Department. This extremely dangerous and reckless behavior continues for approximately 8 minutes, from the time of lights and sirens to the time he stops that vehicle in that parking lot. And the entirety of this is captured on Sarasota Aviation. The entirety of this is captured on video. And again, law enforcement is very clear. They immediately cut off. They do not pursue. They do not attempt to apprehend. And yet, even with no law enforcement surrounding him, he continues these actions, Your Honor. This is why the state feels that equal offender is not appropriate for this defendant. This defendant has shown a reckless disregard for the safety of persons and property in our county and Hillsborough County. And the state feels that a sentence of 5 5 years in the Department of Corrections, followed by 5 years of probation. So we would ask that in one case it be 5 years DOC straight, and in the other case we'd ask to run consecutive probation to that, and that would be 6 or less.
Thank you. All right, at this time, having accepted the plea, the court does recognize the age of the youth. The actions are incredibly dangerous, but I also recognize that youthful offenders designed to try to get some rehabilitation in. The court will, at this time, designate Mr. Wright as a youthful offender, adjudicate him guilty of that offense, but I am going to sentence him to 2 years in the Department of Corrections as a youthful offender, followed by 2 years of community control, followed by 1 year of straight probation. Those cases will run concurrent in 22-1974F, where there'll be court costs in the amount of $415, but on the other one. $415 in court costs, $100 cost of prosecution, $50 public defender application fee, and a $100 fee for service of public defender. Did he also get charged? Did he plead to the resisting?
No, it's in this.
That was no person. All right. Sir, you'd have, of your probation, you'll have 24 of the 36 months of supervision to pay those costs. As it relates to 22-1975, fleeing and eluding, which was reduced by the state to a third-degree felony, lessening it from a second-degree felony, the court will adjudicate you guilty of that offense as a youthful offender, sentence you to 2 years in the Department of Corrections, followed by 2 years of community control, followed by 1 year of regular probation. I am going to indicate that there'll be no early termination of either the community control or the probation. I want to make sure that if you really are going to learn something from it, then you're going to go ahead and do well. If you don't, you'll come back and we'll be facing the balance of whatever I can do on a consecutive sentence for you. Let's see. $450 in court costs, $50 $100 cost of prosecution, $50 public defender application fee, and a $100 fee for services of the public defender. Was the operating without a motor vehicle license, was that pled to? Or
It was null prost.
Null prost. And the reckless driving was previously dropped, right?
That's correct.
Sir, on that case, you'll also have 24 of the 36 months to pay off all the financial obligations as well. As a condition of the fleeing and eluding, I'm also going to require that you do the 12-hour driver improvement course. The driver's license is suspended in that case. I believe it's a minimum, right? What's the minimum maximum?
The minimum is 12 months. I don't believe there is not.
I think there's.
I believe the minimum is a year. I don't believe it.
It's 5. It's the minimum. So I'm going to suspend your driver's license for 2 years as well. All right. If you qualify for a hardship license through DHSMV, I have no objection. Is there anything further we can address on this case?
In case I didn't hear, Judge, it's a concurrent sentence.
Concurrent sentence. Yes. DNA sample for placement in the FDLE database as well. Mr. Wright, good luck to you. All right, you're remanded to the custody of the Charlotte County Sheriff's Department for transport to the Department of Corrections.
You get credit for all time served.
Credit for all time served.
Okay?
All right.
We'll talk.
Thank you. Good luck. Elizier Serrano, Mr. Weinberg, or Mr. Rios.
Good afternoon, Your Honor. Jim Rios on behalf of Mr. Serrano.
Good afternoon, sir.
Your Honor, by way of brief history, if I may,
Please.
I believe Mrs. Serrano actually had an injunction, and she moved to dissolve the injunction in December, and it was granted by Judge Evans. At that point, we filed a motion to remove the no contact order on the criminal case. When we were before the court last, if I remember correctly, the court denied the motion without prejudice in order for us to bring in Mrs. Serrano. I believe that she is here.
Mr. Serrano, if you could come forward, please.
And my understanding was that Your Honor didn't want to rule on it until you heard from her.
State. Do you know who your attorney name? Who is your attorney?
Martina.
Ms. Hedvicek? All right. Well, I don't know that I can require an attorney to come for the victim in the case. I asked for it in case, because I didn't want him calling directly, but
Right.
I think that's probably why we did it. If you'll both raise your right hands to be sworn, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. Did you have any questions for Ms. Serrano?
Yes, Ms. Serrano, could you please state your name for the record? And it is my understanding, and correct me if I'm wrong, that you do wish to remove the no contact order? Are you afraid of Mr. Serrano at this time? Do you believe that it's in your best interest to be able to work out the issues y'all have? I have no further questions, Your Honor.
Mr. Patterson? Ma'am, do you understand that you do not have that you're just agreeing to this because you don't want to live without the financial support